So we're going to get started, and some more people will join us as we go. Hi, everyone. I'm Nancy Hoffman-Vaniak, CEO of the Greater San Fernando Valley Chamber. I want to welcome everyone to today's webinar, Why Your Website Might Get You Sued in 2020, presented by Mark Widower, owner of webcompliancepro.com. Oh, someone's calling my cell phone. Can you believe it? I'm gonna, hold on, I gotta put it on silent. Okay, everyone else, you're on silent except for me and Mark, apparently. We're excited today about doing this webinar. If you were at the breakfast yesterday, I talked about it a little bit, about how websites have new changes according to the ADA and some privacy regulations in California. And even when we posted this webinar on our website, someone said, well, your website isn't in compliance, because there are people who are trolling out there just waiting to find an attorney to take down, like a shakedown lawsuit. So on this webinar today, Mark's going to go over what these regulations are, which regulations apply to you and your website, why these regulations are scary, which is a little bit what I just told you, and what it means to make your website accessible for those with disabilities, and what you need to do next. You know, we've noticed as a chamber over the last year, Mark has noticed this too, that there's a threatening trend online for people to troll these websites and want to sue people. And so I'm now going to, before I turn over to Mark, give you a couple housekeeping tips. We have everyone on mute. If you have a question, you could type it into the webinar. Please do it into the Q&A and not the chat. It's hard for me to see both at the same time. So you can type it in, and depending on the time, we will either take them as we go or we'll take them at the end. Everyone can see the questions you posted if you have your chat screen open. If you have the same question as someone else, there's a little thumbs up, and you can give it the thumbs up, and that will upvote it and move it up in queue. So now I'd like to introduce Mark, who I'm looking on all my notes for his bio, which, Mark, I don't see what page it's on.
It is on page 2, on the one
on page 2
with my picture.
Well, so rather than me tell you about this, I'm going to introduce our expert. Let me tell you, I've known Mark for a long time. He's been a member of the chamber over 20 years. His wife makes an amazing challah, which he's actually passed on to me on the corner of like Shoup and Victory one time. And for the next 30 minutes or so, he is going to go over the website compliance, and his expertise is in website compliance, development, and marketing. And he's also a search engine optimization specialist. He founded his company in 2011, and he's well known for building websites for businesses, including several of our members that tend to outrank their competitors on the first page of Google for all sorts of important keywords. At this point, he wants me to say something flattering about him, but I already told you about the challah. He did listen to me when I gave him some advice about when he had vertigo, and most people don't listen to me when I give them that type of advice, and he said I was right, and no one ever says I'm right either. So thank you, Mark, for that. So I'm going to turn it over to Mark, who's going to tell you all about what you need to know. Let me just advance the slide really quick. Give me 1 second. Here's a picture of Mark, so you know what he looks like. And I'm going to stop my sharing. He's going to pick up from here and start his portion of the webinar.
And there we go. And I think everybody would do better, Nancy, if they were to take your advice. I mean, that's just a better way. It's just a better way to live, right? Mm-hmm. Anyway, thank you for the introduction and the compliments about my wife's challah. I'm looking forward. I'm very thankful to have this opportunity, because the chamber does that so often, right? It's always letting people know about regulations and such, and this is important stuff. So anyway, so it is really important, as you said, for all business owners and managers to know about these regulatory threats that could really damage your business, threats that could blindside them with civil lawsuits, fines, criminal penalties, the cards all fall the wrong way. You know, there's such a severe threat to businesses. I've been going back to all of my clients, all the businesses whose websites we built over the last 18 years. Actually, the business started in 2001, and we've been informing them about these same risks. And almost everyone I've spoken to is shocked by what they've learned, and that they're all asking me to help them update their websites so that they can avoid these threats. But look, whether anybody on this website asks me to help or not, everyone should at least handle this stuff and protect themselves. Talk to your own web developer. That's really what's most important. What I do want to mention first, however, is that I am not an attorney. and I'm not giving any legal advice here. What I am doing is informing you and everybody else on the call of what's going on in the web development industry with respect to these regulations and some of these technical issues and solutions regarding those regulations. So for legal advice and opinions, please consult your own attorney. So now that that's out of the way, let's get started. Our goal today is to do two things basically. First, it's to educate business owners about the mostly new regulatory threats. And second, it is to tell them about how they can quickly and easily protect themselves. But kind of in a nutshell, the real goal is to make all of our guests on this call less of a target for the fines, penalties, and lawsuits that other business owners may need to deal with and ultimately pay for. So basically, there's two areas of website compliance that we're going to be talking about today. One of them, generally speaking, is called privacy compliance. There's one brand new law and then another one that's a couple of years old that are both about privacy that have steep fines and possible criminal penalties, actually. And then there's there's accessibility compliance, which I know more people are interested in because they've heard about all of these Supreme Court decisions and the shakedown lawsuits and everything that you just mentioned for the people whose websites are not compliant. And then these lawsuits end up costing the business owners tens of thousands, sometimes even hundreds of thousands of dollars, and it's really very nasty. So even though there's probably greater interest in the accessibility compliance, I'd be really doing a disservice to everybody if we didn't talk about the privacy compliance first. So the question we'll start with is, who owns the data about you? Ever since the internet was created, whichever website or company collected data about you owned that data. They could do that, they could collect the data and do with it whatever they pleased, including using it to influence your habits, your politics, your buying decisions, or just about everything else. That's been in the news a lot. And now privacy compliance laws are that we're going to be talking about today are written to change all of that. They both say, these two that we're going to talk about, that you are the owner of any data about you and that you get to decide what is done with it. So the first privacy regulation that we're going to talk about is called the General Data Protection Regulation, and it's from Europe. It became effective on May 25th, 2018, so that's about a year and a half ago now, almost 2 years. And the GDPR defines a new class of people called data subjects, which the regulation seeks to protect. And these people include all citizens of the EU, all residents of the EU, no matter where they happen to be. And data subjects also include any resident or citizen of any other part of the world who happens to visit the EU. So billions of people altogether. And basically what it does is it makes data subjects the owner of the data about them, no matter where those consumers are or which websites they visit. So they can be in the EU, they can be in the United States, they can be in some other country, but they own the data that is collected about them. So as a result, it affects websites and companies worldwide, and the penalties for violating the GDPR can include fines up to 4% of your gross annual revenue, or up to $22 million. It's really 20 million euro, but that's about $22 million. And then there are potentially some criminal penalties as well. And the GDPR is why over the last year or 2 years, really, you've seen a whole lot of notices on websites. Nancy, you've seen this, right? When you go to a website for the first time and it says, this website uses cookies, please click here to agree.
Well, I get it every single day, but they haven't offered me any Thin Mints, so I've kind of just been not accepting them.
I bought Thin Mints yesterday. Anyway, the reason that you see them is because the GDPR requires that you be notified that the data, that you know that data is being collected about you. And cookies, frankly, those are data. Cookies are one way to store the data that's being collected about you.
So what if you say no? What happens?
Well, then the functionality of the website might change. It depends on what kind of cookies they are and the reason that they're collecting the cookies. But I mean, you can try it out. It could be different on any website, but generally you won't notice a difference. But there won't be tracking things like, for example, when you go back the next time, it won't pick up where you left off. I'm sure you've seen that kind of a thing. But it also, for example, won't, like in some cases, just a marketing cookie. And so that cookie might store information about how you got there originally. And then when you come back the next time, then it won't recognize that you're the same person that got there, let's say from a certain ad or something, right? So it won't matter a lot to you in many, many cases. It'll matter more to the website. Does that make sense?
Yes.
Okay. So anyway, the GDPR grants, that's a good question, by the way. The GDPR grants data subjects 8 specific rights, and among the most significant of those rights are the right to be informed, which means that you must be informed when data is being collected about you, about maybe people get there, and the legal reason for collecting that data and how the data is going to be used. And it grants the right to access, which provides users with complete transparency in data processing and storage. What data points are being collected, so you get to know all these things that you just asked me about, right? Where are these data points being processed and stored, and the reason behind the collection, the processing, and storage of the data. And users will also have to be provided a copy of their data if they request it. The right to be forgotten gives users an option to have data about them erased, so as well as to stop further collection and processing of their data. And the process involves the user withdrawing consent for their personal data to be used. So they would, that you could actually, the GDPR requires that you allow people to write you and say, hey, delete me. I want you to forget about me entirely. And then they have to delete all the information that they have about you. There's a right to data portability in the GDPR, and that gives users a right to, and this might sound strange, a right to download the personal data that that they've previously given consent for, and then send that data to a different organization. These organizations that the regulation calls data controllers, but you can send it to another website who, let's say, might be able to use that same data for you. It's not something that we can probably comprehend its use of, but anyway, that's one of the things that you should be able to do within the GDPR. And then the right to restrict gives data subjects the right to prevent their data from being given, shared, or sold to other data controllers, right? So, and that's something that's very common with internet marketing is companies, they sell data from one to the other. I think you've heard about that in the news too. The GDPR also requires that companies conduct a data audit so that they know what data they are collecting, regardless of whether they're currently collecting it or have already collected it. And then how and where it's being collected, how and where it's being stored, and how it's being protected. Companies are also required to have a legal justification for storing the data. And companies are required to keep all their consumer data secure. So it's a lot like HIPAA that requires all health and medical data to be kept secure. The GDPR makes the same kind of requirement for all consumer data. The goal, of course, is to prevent a data breach, which is all too common today. And that applies not only to the data that is collected and stored on the web server, but also the data that you store in your company's office network. And companies are also required to have a plan in the event that their data is breached. And it's worth noting that having a breach will cause one level of fines and penalties. But if you don't have a plan to deal with the breach, which is required by the GDPR, and then if you don't execute a plan, if you are breached, then you end up at a higher level of fines and penalties. So they have like intentional and unintentional kinds of fines. For larger companies, you need to appoint or hire somebody called a data protection officer who has to have intimate knowledge of the GDPR and also technical knowledge and other kinds of legal knowledge. And of course, I'm just covering the high points, or I guess the low points, depending on how you view all of this. But you can go to GDPR.EU and you can read the complete regulation. So that's the GDPR, and that's all I was going to say about that. Do you have any thoughts, questions, fears about that, Nancy? I'll assume no. Anyway, so that's been around for almost a couple of years already.
Wait, Mark, sorry. I was on
no
mute.
worries.
I do.
Yeah, no worries.
From Russell Lookadoo, how do we find out what data your personal website is storing? How do people know what data is being stored?
That's a great question. So when we do GDPR compliance for a website, we have a piece of software that does analysis to figure that out. So it'll list all the cookies that are being stored. It'll find all the forms on your website, and just everything else that the website's doing. And then that information, as I kind of implied earlier, needs to be posted on the website. You have to say, we collect this information for this purpose, right? So in other words, we collect data from our contact form so that we can respond to your questions. But it's more intricate than that, but that's part of it.
Okay.
Anyway, so the GDPR has been around for a couple of years already, and here's what's brand new. On January 1st, the California Consumer Privacy Act went into effect. That's just a couple months ago. And it's similar in purpose to the GDPR in that it wants to make the consumer the owner of the data about them. But what's interesting is that not all companies need to comply. You only need to comply if you meet one of three thresholds. The first one, if the company has in their databases 50,000 names of California consumers or families or devices, or if they make half or more of their money by selling consumer data, or if they do $25 million of revenue or more each year. If you don't meet one of those three thresholds, then the CCPA does not apply to you. So, which I think is probably a relief to a lot of people, right? They probably heard about this new California law and thinking, oh my gosh, I have to comply with this one. Chances are, if you don't, well, chances are most of the people on the call don't meet these thresholds. So anyway, the penalties are kind of stiff and can include fines of up to $7,500 per infraction, $750 per breached or stolen data record, and potentially up to $750, and this is, you know, for big companies, $750 per California resident for more serious violations. There's 40 million residents. So there could also be civil class actions, and there could even be criminal prosecution. So it's pretty nasty stuff. The CCPA also specifies some similar rights as the GDPR, but uses different words to describe them. For simplicity, I'll describe them in the similar terms as possible. And remember, these aren't all the details, but a general overview of what the CCPA regulation says. But first, there's the right to be informed. California residents need to know what personal data is collected about them, and whether the information is sold, disclosed, and to whom. Consumers have the right to prevent or restrict the sale or use of their personal data. And they have the right to access data about them. So these are all similar. And they have a similar right to be forgotten, to have their data deleted. And then this one is different. They have the right of non-discrimination, which basically says that a business can't discriminate against a consumer if they have exercised any of the other rights in the CCPA. So for example, if you've asked to view your data or transfer your data or something like that, they can't charge you extra for purchasing the product or discriminate against you in some other way. So for both the GDPR and the CCPA, they both require security not only on your website, but in your company too. And you'll want to make sure that you have good cybersecurity protecting your office computers and your whole network. And I know, Nancy, that the Chamber has lots of good resources for people like that. The cost for compliance for both GDPR and CCPA are relatively low, at least for the website part of this, but the internal company compliance part can be quite expensive because you really have to lock down your network and your data to keep everything secure. Just keep in mind that whatever—
Mark, we have a question.
Sure.
You mentioned that having a plan on how to deal with a breach. What does one do if there has been a data breach on their site?
Well, among those things you have to, okay, so with cybersecurity, you need to be able to track what happened. You need to be able to figure out which data was accessed, how they got in, and that would all be part of your plan, right? To be able to access your systems that you've set up in order to track such things. And then you also need to, because you're going to need to know which data was breached, you need to be able to inform the people whose data was breached and make some kind of a accommodation for them. But at minimum, they have to know. And there's more. I mean, the CCPA goes on and on about, and the GDPR also, they both go on and on about how to, what these plans need to have. But basically, you need to be prepared. And then you need to, like, let's say, for example, that you had your whole customer list on your website, and somebody got in and was able to steal all the customer, download all the customer information. They got the names, the addresses, and all that kind of stuff. It's your duty to inform all of these people that their information was breached. And if, for example, it was information that might influence their credit or something like that, you might have to provide credit monitoring for them and so on.
Okay.
So that's certainly not a complete answer, but that's the spirit of what you would have to do. So. Okay. So anyway, so whatever the costs are to get compliant, the costs of violations are a lot higher than the cost for compliance. And in case you missed it, what's really strange about this is that the European law applies to every business website, but the California law applies to very few websites, and probably not most of the people on the call. So that's the basics of privacy compliance. And if there's any other questions, I'm happy to take those. After that, we'll move on to the accessibility compliance.
No other questions right now.
Okie dokie. All right, so now we're going to talk about accessibility compliance, and this is all about making your website accessible to people with disabilities. And there are 3 real good reasons that you would want to do that. First, it's to help benefit people with disabilities. They have as much right to enjoy the internet as the general population does, and the ADA was designed to help protect that right. But setting the laws aside, it's just a nice thing to do. Now keep in mind that there are 10 to 15% of all people in the United States that have one kind of disability or another. So the next reason to make your website accessible is to potentially increase your business by that same 10 or 15%. So, I mean, you're not going to win business, that have a boost of 10 or 15% right away, but I can pretty much assure you that you're not getting any or most of that business if your website's not accessible. And the third reason, and this is the reason that most of you are probably on the call here today, is to protect your business from expensive lawsuits, especially frivolous shakedown lawsuits that you were mentioning at the beginning, Nancy, that could cost you tens of thousands of dollars and even put you out of business. So what do I mean by shakedown lawsuits? Well, the Americans with Disabilities Act was passed in 1990, and there are people, some attorneys and some are just professional plaintiffs, who have made a business out of suing other businesses on the basis of the ADA for physical and structural violations. So people are walking into a restaurant. I'm sure, Nancy, you've heard about this, like with business owners in the area, right? People are walking into a restaurant or some retail store and measuring the width of a doorway and the height of a bathroom mirror, or the height of a countertop in retail stores or restaurants, or the width or number of handicap parking spaces in parking lots. And they've even been known to check the shade of blue on the handicap signs in those parking lots. And then they sue or they threaten to sue for minor things like that. So, for example, the height of a bathroom mirror is supposed to be 1,015 millimeters from the floor. And that's literally what the regulation says. But if it's measured to be 1,020 millimeters, they note that as a violation, and that ends up being in a lawsuit for thousands of dollars. And I wish I were kidding, but I'm not. So
Mark,
these
going back really quick to before when you were doing the privacy, a question came in, and I just want to ask it now so that way we don't forget later.
Sure.
If someone's customer list is not kept on their website, but they have it on Constant Contact or Aweber, where those organizations have privacy policies in existence, are those companies liable for the breach, or does it extend to, like me, like I have Constant Contact. So if Constant Contact's breached, does that extend to me too, or is that their responsibility once I've uploaded my members?
I think it would, again, I'm not an attorney. I think it would depend on how they got in. If they got in with your username and password, you might have some culpability, but generally speaking, those companies, these are the companies that are called data controllers that I mentioned earlier. These data controllers are responsible for keeping all of the data safe as well, just as you are. I would imagine that they would be more responsible than you are, provided that you kept your password secure and did all those proper things. I think that's a good question for an attorney, however. Okay. So, all right. So back to accessibility, the ADA lawsuits regarding physical issues are on the rise, and what's really scary about that is that 56% of all California lawsuits regarding physical ADA violations are filed by just 30 plaintiffs, which is that's amazing to me. And by the way, California outpaces any other state in the number of physical ADA violations. These people are professional plaintiffs, and one of them, get this, there's a guy named Scott Johnson. He's a disabled lawyer who's filed over 2,000 cases since 2004. You can Google him to see what I mean. And there are others, a whole bunch of others just like them, at least 29 more. But I mean, there's a lot of people like that whose business it is just to go find ADA violations and sue them. Not that they were ever harmed in any way, but they go looking for these things. In 2018, the DOJ, Department of Justice, actually issued an opinion saying that the ADA applies to websites, even though neither the DOJ or Congress has ever actually revised the ADA to reference websites. So there's an opinion, but not any actual law. And that's why there's this big gray area about the ADA and websites. Well, making the gray area a little bit darker is the Supreme Court this past October. There was a blind man in 2016, his last name was Robles, who couldn't order a pizza from Domino's website. He sued and he lost, and he appealed to the Ninth Circuit and he won. So then Domino's appealed to the Supreme Court, and they said, sorry, we're not interested in hearing it, letting the Ninth Circuit decision stand. So this got a lot of news just back in October, and the result is that now even more professional plaintiffs who are just opportunists, somewhat evil by nature, without regard to people that they harm, the businesses that they shut down, and these are the people who are most likely to come after companies like yours. And here's what I mean by that. In 2015, there were 56 federal lawsuits filed that mentioned a website with respect to the Americans with Disabilities Act. In 2016, there were 262. In 2017, there were 814, and in 2018, there were 2,258. So these are federal lawsuits nationwide, but California leads the nation in these kinds of lawsuits. And in 2019, we don't have numbers yet, but you've got to assume that the curve is going to continue to look pretty much the same, maybe even worse. So those were just the actual file lawsuits, but threats and shakedowns, pardon me, are even more common, and they get written about in the news all the time, like these headlines: is your ADA website compliant? I'm sorry, is your website ADA compliant? Avoid becoming a litigation target. And businesses struggle to comply with unclear ADA website requirements. Avoiding the website accessibility shakedown. ADA website litigation likely to increase. And here, businesses are sitting ducks for lawsuits because websites are not ADA compliant. And it's headlines like these that have most people on the call concerned. So what are the penalties under the ADA? Well, it turns out they were adjusted for inflation in 2014. So the penalties for a first violation are now a maximum of $75,000. The maximum penalty for a subsequent violation is $150,000. Plus the ADA requires that you fix the problem, which can cost tens of thousands of dollars if you do it, let's say, the conventional way. And then there's a statutory provision that the plaintiff can recover reasonable attorney's fees and costs. And this is where those opportunists make their money, right? They work with attorneys. The attorneys have, they rack up legal fees. And this is what ends up costing business owners so much money. But what really has me worried, and has very few other people that are talking about this, is this. There are laws that effectively overlap and strengthen the ADA. Various states and government departments have drafted their own laws in order to protect their own constituents. And these laws have their own interpretations of what it means to protect the people with disabilities. And of course, they all have their own penalties too. But here's the scary part. The laws I'll mention here either have been written or modified to adopt the ADA standards. So if you violate their law, you also violate the ADA, and then boom, all the penalties are increased or multiplied by huge amounts. And here's what I mean. According to Housing and Urban Development, the FHA, the Fair Housing Act, protects people from discrimination when they are renting or buying a home, getting a mortgage, seeking housing assistance, or engaging in other housing-related activities. So naturally, just as the ADA is extended to apply to websites, the FHA is being extended to apply to websites related to housing. This is what I whispered to you during the meeting yesterday, Nancy, that in other words, since you can't discriminate on the housing itself, you also can't discriminate on access to housing, which includes websites that rent, lease, or sell housing. The National Apartment Association published an article that says exactly that. So if you're in the real estate business, whether it's real estate sales, rentals, leasing, or even mortgages, you can imagine how this applies to you as well.
So even a mortgage broker would have to follow this, for the Housing Act part of it.
Well, it's that they have to follow the ADA on their website so that if someone were to sue them, they don't also get sued on the basis of the FHA.
Okay.
Right. So, I mean, the FHA just says you can't discriminate, and so but they don't give you specific ways to discriminate or not discriminate. So these damages, for the FHA, they can be as bad and sometimes worse than the ADA. Plaintiffs could be entitled to receive payment for actual damages, emotional distress damages, injunctive relief, equitable relief, attorney's fees and costs, and a civil penalty to HUD for up to $16,000 for a first violation, $37,500 if it's a second violation within 5 years, and $65,000 if it's a third violation in 5 years. And even if you're not in the real estate business, state and local laws can make website ADA violations far worse than the ADA alone. So I think everybody here on the call is in California, but we have our own state disability law that most people haven't heard of, called the UNRRA Civil Rights Act. It's named after Jesse Unruh. And this is it's also backwards looking, which means that even if you fix a problem now, if it wasn't ADA compliant in the past, or if it violates the UNRRA Act in the past, you still could be sued for a violation. And so what are the penalties under the UNRRA Act? They're 3 times actual damages, plus attorney's fees and costs, plus injunctive relief, and $4,000 in statutory damages per offense. So get this, Nancy. You know what an offense is?
Yeah.
Each time you visit the website.
Oh my God.
So if you visit the website 10
times, how far retroactive does this go back?
The source that I found on this did not specify, but I think the point is that you just get it fixed and try to avoid it. I mean, try not to get sued in the first place. I don't know how far it goes back. Another good question for an attorney. And here's also, I mean, California is not the only state that does this. New York State and New York City each have their own civil rights, or I should say disability laws that they call human rights laws, which can also add thousands of dollars to a website ADA lawsuit if you live there or if a website is based there. So if you're thinking that your little website is kind of too under the radar to be caught, here's some more bad news. On cable TV, you'll see advertisements for things like, do you have mesothelioma, or have you been exposed to asbestos, or followed by, well, you have rights, let us defend your rights. And you see the same thing with talc and Roundup and lots of other issues. Well, those same marketing companies that generate those kinds of leads for lawyers are now beginning to generate leads for ADA lawsuits on the web. And I happen to know one of the owners of one of those lead gen companies, and she told me about this. And so they're going to be commercials on TV saying, hey, if you're a blind person or visually impaired or lack motor skills or something, and if you've been somehow denied access to a website or not been able to enjoy or use a website fully as a result of your disability, then then we can come talk to us. And there are people who exploit these laws for personal gain, opportunists, like we mentioned before, who are just filing lawsuits to make money, not to help those with disabilities. And they're looking for websites like yours belonging to companies like yours with little or no budget for a legal defense. For example, the LA Times published an article in 2018 about this little Avanti hotel in Palm Springs. They were sued over website ADA violations, and the attorney for this little hotel says that they're going to have to settle for between $8,000 and $13,000. I think they're getting off kind of easy, but based on the other reports that I've heard, but that's $8,000 or $13,000. Also, probably does not include the attorney's fees, and it doesn't include the cost of then fixing the site to prevent more plaintiffs from suing the same company. So remember this chart? I mentioned it represents ADA lawsuits, federal ADA lawsuits only, but these statistics do not reflect the many state and industry lawsuits that overlap the ADA. So some people, I mean, you can sue under the UNRRA Act and not under the ADA, or you can sue for FHA, not the ADA. There's tens of thousands of demand letters like the one that the Avanti Hotel received. So the stats also don't include the millions of dollars in out-of-court settlements that are paid to plaintiffs, or the millions of dollars paid to the plaintiffs' attorneys in ADA mandated fees and costs. And while these laws generally require that you fix the problem, and until you do, none of these laws prevent another plaintiff, a second or third, from suing the same site, the same business for the same reason. So you can end up with 2 lawsuits at the same time. And you can also settle with one plaintiff, and if you haven't repaired your website, you can have the same problem with a second plaintiff or a third. Okay, so you must be wondering, well, what does the ADA actually say? Title III of the ADA is for private companies, for businesses, and so it says that no individual may be discriminated against on the basis of disability with regards to the full and equal enjoyment of the goods, services, facilities, or accommodations of any place of public accommodation, that's the term, by any person who owns, leases, or operates a place of public accommodation. And then it defines what public accommodations are. And they include, like most places of lodging, hotels, motels, any kind of facility for recreation, could be a theater, could be any kind of an attraction or amusement park or something. Transportation, education, restaurants, stores, service providers too, care providers, places of public displays, all these things, shopping mall and so on. That's what a place of public accommodation is. But now the DOJ is saying that the place of public accommodation not only applies to the physical place, but also applies to the websites that allow people to prepare to go to those places. Like in order to make a reservation at a hotel or a motel or a restaurant, or to be able to buy tickets for something, or to read restaurant menus, or to read about a business's services, or to learn about a business in general, or to read the articles that the business publishes, and you can kind of let your imagination run. Anything that you can put on a website to do with business that you run is now part of that place of public accommodation. So what that means is that all people must be able to use your website, including people who have limited vision, people who can't see at all, totally blind, people who have limited hearing, people who can't hear at all, those who cannot move a mouse, those who cannot use a keyboard, and even people with cognitive disabilities and other disabilities. All of these kinds of people need to be able to use your website. So you might be wondering, well, if the ADA doesn't mention websites, how do you make a website ADA compliant? Well, when we say a website needs to be ADA compliant, what we really mean is that it needs to be accessible for people with disabilities. It's that word accessible that's the key. We've all heard of HTML and HTTP and all these other internet acronyms and technologies. Almost all of them were defined by an organization called the World Wide Web Consortium. In 1999, way back then, the W3C began developing a standard called Web Content Accessibility Guidelines, or WCAG, specifically to help people with disabilities access the internet. And now they're up to version 2.1 of the WCAG. Within the WCAG are different levels of accessibility, designated as single A, double A, and triple A. And while the DOJ has not yet said that WCAG defines the standard for the ADA on the web, the generally accepted standard cited in most cases and the standard that allows just about everyone with disabilities to use the web is AA. So when we're talking about ADA on the web, what we're really talking about is meeting all or most of the WCAG 2.1 AA standards. But it will also shortly mean complying with WCAG 2.2, which is due at the end of this year. So things are changing even now. So I'll give you a few examples of things that are in WCAG 2.1. Blind people can't see a website at all. So they need all of the content on the page to be read to them using software called a screen reader. Screen readers generally read the information that appears on the page, but the blind user has to be able to make sense out of what they're hearing. So almost every element on a page needs to be properly coded or tagged. For example, headings need to be tagged as headings, kind of like an outline with levels, with headings, subheadings, subheadings, and so on. Sometimes a lazy web developer will just use bigger, bolder text for a heading, but that's not a heading. It has to be coded, tagged as a heading. Images need to have alt tags. I think we've all heard of these things. And alt tags, they should describe what is shown in an image. For example, if you have an image of your restaurant's spaghetti and meatballs, that screen reader should say something like, photo of our delicious spaghetti and meatballs, instead of something like img1234.jpg. Alt tags are one of the most often cited website flaws in ADA lawsuits. By the way, Beyonce was sued because her website was substantially all images and the images didn't have alt tags. We've all seen buttons and links that say things like read more and click here. But imagine if you're blind and you can't see the content, the context of those buttons and links. The screen reader says read more, but you don't know what you're going to be reading more about if you click it. And by the same token, if you click a click here link, where you're going to go. The pages need to be coded so that everything is extremely clear. And if you think about it, blind people can't see the mouse pointer, which means that they can't use a mouse. So they need to be able to navigate your entire website with the keyboard only. And if you want a quick example of whether your own website is accessible, just try navigating your own website with the keyboard and see what happens. Among other things, you should be able to tab through and select from your website's menu. There's far more things than that are required for someone to use a website with the keyboard only, but that's something that might give you a clue about whether your website's on the right path. People with low vision, so this is now people who are not totally blind, but people who have difficulty seeing, need to have sufficient contrast between the text and the background color behind it. To be precise, it needs to be 4.5 to 1. That's the contrast for the text in front and the color alongside or in the back. The user needs to also be able to enlarge the elements on the website by 2 times or more without breaking the layout of the website. So you can imagine, Nancy, that older websites, they don't have any of these dynamic features, right? And that's what's at issue here with the ADA. People with cognitive disabilities, excuse me?
That's what's wrong with our website, Chamber's website.
Right. And like websites also need to be mobile responsive because, by the way, I'm not really going to get into this very much in these slides, but all of this applies to your website working on a mobile device too, right? So the website needs to be, if it's coded to work properly for desktop, then it's most of the way there also to work properly with the accessibility tools that are built into your iPhone. Your iPhone or your Android phone actually has tools to help somebody who's totally blind or have limited vision to actually see a website or to use a website and to use, frankly, the whole phone. It'll speak to them. It has screen readers and all that kind of stuff. It's all built in. But unless the website's coded with the proper data that the screen reader and the other accessibility tools would use, then it won't be accessible. And that's the bigger deal. And that's the same, by the way, with desktop and as well, because when if somebody has a certain disability, they're going to buy the software that allows them to use their computer. One of those tools is the screen reader that I've been talking about. And if the data is not there on the website to feed the screen reader, then the screen reader is not going to work right. And that's what's at issue. So also, there's people with cognitive disabilities, and they need the ability to adjust or remove timing for things that move or change. So that's because they may not be able to respond as quickly as the web designer designed the site to have them respond. So if something happens in 3 seconds, you got to click here within 3 seconds to do so and so. That would be a bad thing. They need to be able to stop animations, and there shouldn't be anything on a page like flashing lights or screens that could trigger a seizure. So you can imagine, right, if somebody's epileptic or something, they need to be able to turn those things off. Deaf people require captions for all audio elements, which means that you need to caption all of your videos. So if you have videos on your website, like if you're doing helpful things for people and you're communicating with video, you're gonna have to go back and caption all of your videos. So altogether, there's 90 different guidelines in the WCAG. And you might be wondering if the special coding I'm talking about is not automatically part of websites that are being designed today. The answer is that it takes a tremendous amount of work and precision to build a website to be fully accessible. So unless you specifically asked and paid for a website to be accessible, unless the person or the company who built your website told you that the site was going to be ADA compliant, it almost certainly is not. So it's virtually certain that everybody or almost everybody on the call needs to update their website to comply. But for now, the most important thing to do is just to find out whether or not your website is accessible. And to do that, you go through a process called an assessment. And basically, the only way to do that is to have an expert review your site or to have someone who actually has these disabilities use the website and see if it's acting the way it's supposed to act with the tools that they would likely have. A full assessment, which would enumerate all the hundreds of ways your website is and is not accessible. It can take dozens of hours and cost hundreds or even thousands of dollars. A preliminary assessment, which can quickly test the most common accessibility issues and determine if a site is not accessible, is much less expensive. So let's say you have a fuller preliminary assessment done. What then? How do you get your site updated? Fixing your site in this way is called remediating a site. And what most people have done up to now is what we call a brute force manual remediation, which basically means to do a full assessment of the site. And then you go through and they list every item, item by item, page by page, element by element, and recode or redesign the website to get rid of the accessibility issues. Sometimes a website will need to look totally different when they're done, right? Because the contrast issues and the resizing and things like that. Sometimes it takes too much work to remediate, and some people just end up rebuilding their entire website. In November, I had a conversation with an attorney who specializes actually in ADA defense, and he has a 300-page website, and he had to rebuild the whole thing because it would have taken too much work to remediate his website, and so he had the whole thing redesigned, and it cost him about $50,000. So it can take many weeks, could take many months to remediate a website, depending on how big it is. And the technology that was used to build a website, that can influence it as well. A dozen or so pages is going to take weeks to do. A larger site, even one's much smaller than an attorney site, could take many months. So it can take a long time and be very, very expensive, but it's still worth it because it's, well, potentially far less expensive and much less of a hassle than dealing with lawsuits, threats of lawsuits, and the anxiety that everybody's going to have, right, about wondering whether these threats are going to come through. So brute force manual remediation, it's slow. And you can imagine if it's going to take that much time with the actual programming and the design hours, then it's going to also be very expensive. And here's the shocking thing. Manual remediation, the brute force method, is temporary, which means that in a year or two, if you want to change the way your website looks, if you want to change the colors from this to that, or you want to change the style of this, like you're changing your branding in your company or something, you're going to have to go through a manual remediation process all over again. You have to recode all of those things, right? And so it's temporary. And as I mentioned earlier, WCAG 2.2 is coming out by the end of the year, and I think it's scheduled for November. So if you're manually remediating your website, and you're going to need to do it again several months from now. And anyway, so that's how a lot of people still do the remediation. Our process, which I'll mention, is quite a bit different. Actually, we've developed a system called the Intelligent Accessibility Compliance System. And it's a lot faster because we use our artificial intelligence technology to review the entire website and automatically remediate the website between 24 to 48 hours. It's the tool's very, very good, but it's not perfect. It catches about 90 to 95% of the items on the website. And then when we do our assessment, and we check to see if there are any issues still remaining, and that assessment that we do at that point is much smaller because the tool, our technology really, has done most of the work for us. And so we do this thing called a gap assessment. And if there's any issues, there are far, far fewer of them, and then we remediate just those remaining items manually. And then we make, for our clients, we make a video to show you how accessible the site is, and we create an accessibility statement on your website, which, by the way, is a real good deterrent, right? If somebody comes to your website and says, and is interested in the accessibility of your website and are looking to sue you, if they see an accessibility statement that explains all the steps you've taken, that right there is a deterrent from being sued. It's not a defense, obviously, but it slows a lot of people down. And all that stuff that we do there, it takes just a couple of weeks to do instead of many months. As you can imagine, because there's far less manual remediation for us to do, the process is less expensive than old-fashioned brute force remediation. And what really makes our clients happy is that our system is permanent because of three important reasons. First, our AI tool automatically rechecks the website every 24 hours and looks for changes. When it finds them, it does its magic and remediates them as well as it can. And then second, we review your website every quarter, and we look for any other issues that might have gotten past our system. If we find them, then we use hours that we build into the plans for our clients, and we fix it. And finally, our AA technology is already being upgraded to WCAG 2.2. So when that becomes the new standard, your website will already meet that standard. Same way, so that's how we do it. Some people on the call may be wondering if their website can be remediated. Not all websites can. We've, for the last 11 years now, been doing WordPress. We work on WordPress websites, and we specialize in that. We're really good at remediating these websites, but there's other content management systems that we can also work with, like Joomla or Drupal and Wix and Squarespace. And then, frankly, if your website's been updated in the last 5 years or so, there's probably something there that we can work with. If not, we can still evaluate and let you know. And that really brings me to the end here. As a gift to anybody who's on the call today, if anybody wants us to do this preliminary assessment, we're happy to do it, just complimentary as a gift to chamber members. You can just go to webcompliancepro.com/chamber and just type in, a little information about you and the location of your website, and then we'll do assessment for you, and we can just let you know. And then you can take that to your web developer, and you can say, fix this, fix that, and so on and so on. So anyway, I'm out of breath. Well, actually, there's one other little thing I wanted to mention. When I was a kid, I used to really like Mr. Rogers. I thought he was much better than Sesame Street. And my project manager, Lori, found this great quote by Mr. Rogers, which I think makes the point really well. It says, "When the world seems dark, I remind myself that Mr. Rogers once got a letter from a blind girl who wrote that she had heard him say that he owned some fish, but she worried they weren't being fed. So at the end of every following show, he would narrate, 'I'm feeding the fish,' and he would do it just for her." And there's millions of blind and minimally sighted people in the world who can't see the great things the world has to offer, including your website and whatever your business does. Whatever you do could potentially help somebody else live a better, fuller life. And that's really the best reason for updating your website. So thanks for being here today. If you want me
Mark,
to,
we have a couple other questions.
Yeah, I'm not, yeah, sure, certainly.
Let's finish then. Thanks for being here today. Go on.
No, that was it. I was just all good.
Does IACS work with Bootstrap?
Yeah.
Or you know what that means?
Yeah, should work fine.
Okay.
So
and
a
then,
a website built with Bootstrap is already, that's modern technology already, and it should work fine on a website that's built with Bootstrap technology.
if anyone else has any questions, please put them in the chat window quickly. I want to let everyone know that these slides will be sent out to the participants who are on the call. And we will also have, and it probably will not be till tomorrow, and that the webinar itself will be up on our YouTube channel tomorrow afternoon once we edit out some of our chatter at the beginning. And with that, there haven't been any other questions. So I want to thank Mark today for his insight and knowledge and expertise that he's given all of you. Mark is one of our several members who do websites, and of course, as he offered you this great deal to assess your website. But always remember to please use chamber members, and if you don't have an attorney that you need to consult, we have several chamber members who are attorneys that could help you with questions regarding website compliance as well. And with that,
don't forget the data, the cybersecurity stuff that as well. There's a lot of good.
Oh yeah, we did a cybersecurity workshop
yeah.
a few months ago, webinar that RT did for us, and that I believe is also already on our YouTube channel, which is GSFVCC. So go Sam, Frank, Victor, Chamber. On our YouTube channel, you can see the cybersecurity one that RT from Team Logic IT did for us. And we have other members too who also do cybersecurity. So if you're interested in a referral to a chamber member, please reach out to us and we're happy to refer you. And with that, I think I'm going to end this webinar and thank everyone and wish you a great week.
Thank you, Nancy.